Hi, I'm Jason Sullivan of Rathbone Group, and this is on Subrogation. In this video, we're going to talk about Canada. I grew up in Port Huron, Michigan, which is just across the river from Canada. I live in Ohio, where we have frequent Canadian residents from Ontario, especially traveling through Ohio. And I'm licensed in Alaska and Washington, which sandwich Canada. So I feel like I have a lot of experience of motor vehicle collisions that occurred in Canada. One of the first cases I inherited as an attorney involved two Ohio residents, unrelated to each other, that got into an accident while they were on different fishing trips up in Ontario. That case had already been in the court system for 6 years before I got it, and it was another 3 or 4 before we were finally able to resolve it. The case went on and kind of exemplifies these different issues that come up when we're dealing with citizens of different countries. So if you have a subrogation claim that deals with a Canadian citizen or a U.S. insured that's in Canada, you may face some of these obstacles or just perplexions of what to do. Let's start with first when a U.S. resident has an accident in Canada. Now, I'm not licensed in any province in Canada, but we do have clients whose insureds travel to Canada, and frequently they have accidents and our clients say, can we do anything about this? Do we have a right of subrogation? Our insured wasn't at fault, but can we get the money back? In Canada, many of the, especially eastern provinces, had a system and still do have a system called direct compensation. If you look it up on the internet, it looks a lot like NoFault Laws. Essentially, when parties are in a collision, they're going to turn to their own insurance carriers who are going to take care of their losses, and there's no right to sue or seek reimbursement or subrogation rights against that other carrier. Many insurance companies look at that and say, we just don't have a right of subrogation, and most of the time they're correct. There are exceptions, and so if you do have a case where you think the exception may apply, you're going to want to talk to an attorney licensed in Canada, and we can help put you in touch with someone that can assist with that. There were 2 provinces that until very recently did not have that direct compensation formula. Rather, British Columbia and Alberta did have a fault-based system. In those cases, when there is a collision, it's a lot more like what you expect in a U.S. state, with a comparative fault regime where each party could sue each other for the damages and the at-fault party would have to pay the not at-fault party back. That changed, however. In 2021, British Columbia adopted more of a direct compensation, and as of January 1, 2022, Alberta has adopted the same thing. That has a big discouragement for any subrogation claims because now all of the main provinces with high levels of population act a lot more like a no-fault state where an insurance carrier is going to pay for their insured's damages and they're not going to have any recourse to get that money back. There are some territories that haven't adopted that, but they're so sparsely populated and have so little traffic flow that it's very unlikely that you're going to have a claim. But let's look at something I'm a lot more familiar with because I'm licensed in many states in the United States. Florida and Hawaii especially, where it feels like just like the rest of everybody who lives in the north in the United States, the Canadians also want to go to those warm, sunny places to vacation and relax. I'm licensed in Florida and Hawaii, and so I see these cases quite frequently, where a Canadian citizen is on vacation, and of course, to ruin their vacation, they're in a collision where they're at fault and have damaged somebody in the United States. Our client will pay out for those claims and then try and get that money back. What you need to do is look at the laws in those states to determine whether or not you have a subrogation claim. It's not really going to matter that the person was from Canada. If they're at fault for the collision and those state laws are going to hold them at fault, then you likely have a good cause of action and a right to pursue subrogation. Where it gets a little tricky, though, is if you do have to file the lawsuit and serve that citizen who lives in Canada, you're going to have to follow more difficult and costly rules to certify the service of process through the HAGUE Convention. What the HAGUE Convention is it's international law that countries have signed on, and both Canada and the United States have signed on to this. And the HAGUE Convention sets forth the rules by which you have to properly serve a person to put them on notice of a lawsuit. It goes back to the rules of due process and making sure that people have a fair chance to bring their defense into the court. With the HAGUE Convention, a lot of times it's going to require personal service and you're going to need to translate from English to French, especially if it's in Quebec, the summons and the complaint so that the person has an opportunity to respond. This gets really difficult in jurisdictions that have limited times from when you serve to get that return back and file it with the court. Hawaii is such a case. And so I know anytime that I'm pursuing someone who's gone to Hawaii and unfortunately had that accident, that I'm going to have to be very diligent in making sure that the process server does everything by the book to meet the HAGUE Convention standards, as well as get that return to me in time so it can be filed with the court so that we meet those state deadlines for civil procedure. For On Subrogation, I'm Jason Sullivan. If you have any videos or other international questions that you might want to ask, please feel free to email those to us at video@rathbonegroup.com. Otherwise, I'm Jason Sullivan, and that's the long and short of it.